Welcome to Employment Law This Week. I'm George Whipple. Our top story, the EEOC releases its fiscal year 2015 enforcement data. Retaliation claims were once again the #1 type of charge filed, up 5% from last year for a total of 44.5% of all charges. Race claims were second, making up 34.7% of claims. 30.2% of charges allege disability discrimination, up 6% from last year. Ron Green has more on what's behind the numbers.
Current data coming from the EEOC reflects the fact they're trying to do more with less, meaning that they are bringing directed charges from district offices, which are bottom-up charges that don't require charging parties, and cases signed by a commissioner also not requiring a charging party. The directed charge is only available to them under the ADA and the ADEA. The commissioner's charge is available to the EEOC with respect to any issue that may arise under the law they principally administer, Title VII of the 1964 Civil Rights Act. We can expect to see an increase in ADA litigation and ADEA litigation, especially using the process of the directed charge. We can expect to see an increase in commissioner's charges and significantly more retaliation claims standing alone, not even dependent upon an underlying claim of discrimination being advanced in one charge.
Unorthodox company policies lead to an EEOC religious discrimination claim. The EEOC and United Health Programs have filed competing summary judgment motions in a suit about a belief system called Harnessing Happiness, or Onionhead. Employees of the company are compelled to participate in the program, which includes thanking God for their employment and telling coworkers, "I love you." The company fired 3 employees for not participating. In doing so, the EEOC claims that United Health Programs violated Title VII's religious discrimination prohibition. Religion and religious practices are defined broadly under Title VII. So the court could conclude that the discrimination prohibition applies in this case, even though Onionhead is not a religion based in any recognized or avowed theology. The first case alleging denial of health insurance under the Affordable Care Act can proceed. A New York Dave & Buster's restaurant transitioned a group of employees who had been working over 30 hours per week to part-time, effectively disqualifying them from getting health insurance under the ACA. In a case of first impression, a class action lawsuit claims that the decision to cut employees' hours was made to avoid health care costs. The Southern District of New York denied Dave & Buster's motion to dismiss and also ruled that the company may be required to repay the employees for lost wages under the Employment Retirement Income Security Act if the court decides in their favor. The recent death of Supreme Court Justice Antonin Scalia could have an immediate impact on employment law this term. In nearly 30 years on the court, Scalia left his mark on employment law, writing important decisions in favor of employers and employees. But the sudden passing of the court's most influential conservative justice could change the outcome of a landmark California case alleging that mandatory union dues violate the First Amendment. The possibility of 4-4 splits on the court has implications for all the cases the justices are considering this term, but most importantly, for those expected to be contentious, as in the union dues case. Such a split in this case would leave in place the Ninth Circuit's ruling that allowed public employers to require union and non-union members alike to pay union fees. Finally, it's time for our tip of the week. Sean Smith, General Counsel for Nice Pack Products, is here with some advice on effective social media policies.
Social media can be a great tool for a company to get their message out to the public, but if used incorrectly by employees, it can lead to reputational damage and legal liability. For this reason, it's important to develop a strong social media policy. First and foremost in the policy, you need to let employees know that they are responsible for what they post online. They need to use very good judgment and assume that they're not going to be anonymous, and that anything that they say can spread. Transparency is key, so that when your employees post any comment at all about your company's business, they should know that they need to identify themselves as a member of the company. This is important for credibility reasons and also for legal reasons as well. Let employees know what is expected of them and what the consequences would be if they violate the policy. You do not want any disciplinary action that you take to come as a surprise. If you take the time to establish, communicate, and train employees on proper social media usage, you will find that you can harness the power of social media while avoiding the pitfalls.
Thanks, Sean. That's it for Employment Law this week. One note before we go, no show next Monday, but we'll see you back here in 2 weeks. Thanks very much for watching, and we'll see you next time.